On Friday, February 20th, 2026, 6 justices of the United States Supreme Court told the President of the United States something no court has told a sitting president in modern history. You cannot do this. The tariffs you imposed on virtually every country on Earth, the tariffs that reshaped global supply chains, triggered retaliatory duties from dozens of nations, raised consumer prices by over $1,000 per household, and pushed the effective U.S. import duty rate to its highest level since 1936, are unconstitutional. You exceeded your authority. The law you used does not give you the power to tax. Only Congress can tax. And tariffs are a tax. The case is closed. 6-3. Written by Chief Justice Roberts, joined by Gorsuch and Barrett, 2 justices the President himself appointed. That is not a liberal court overruling a conservative president. That is the President's own nominees saying, "You went too far." And what happened next, in the hours and days after that ruling, is one of the most extraordinary sequences of economic policymaking in American history. Because the President did not accept the decision. He did not pause. He did not consult Congress. Within hours, on the same evening the ruling came down, he signed a new executive order imposing a 10% global tariff using a completely different law. Section 122 of the Trade Act of 1974, a statute that has existed for over 50 years and has never been used, not once, by any president, ever. The next morning, Saturday, he raised it to 15%, the maximum allowed under the statute. And here is the part that changes everything. Section 122 tariffs expire automatically in 150 days. That means they last until late July. After that, they are gone, unless Congress votes to extend them. And Congress has shown no appetite for tariffs. With midterm elections in November, voting to extend unpopular duties that raise prices on voters is political dynamite. So the clock is now running. 150 days. And the question the entire global economy is asking right now is, what happens when the clock runs out? Let me walk you through exactly what the Supreme Court ruled, why it matters, what the administration is doing in response, and what it means for prices, jobs, trade deals, and the stability of the global economic order. Because this is not just a legal story. This is the story of what happens when the most powerful economy on Earth discovers, in real time, that its signature economic policy was built on a legal foundation that does not exist. The law the President used to impose tariffs was called IEEPA, the International Emergency Economic Powers Act. It was passed in 1977. And to understand why the Supreme Court struck it down, you need to understand what this law was actually built for. In the 1970s, Congress was worried about executive overreach. Presidents had been using an older statute, the Trading with the Enemy Act, passed during the first global conflict, to justify all kinds of economic actions that had nothing to do with enemies or conflicts. In 1971, President Nixon used that law to impose a 10% import surcharge and suspend the gold standard. Congress decided it needed to draw a line. So it passed IEEPA, a new, narrower law that gave the president emergency economic powers, but only in response to an unusual and extraordinary threat to national security, foreign policy, or the economy. The president had to declare a formal emergency, and the powers were specific: freezing assets, blocking transactions, prohibiting financial dealings with designated entities. Over the next 49 years, every president used IEEPA. Clinton used it against narcotics traffickers. Bush used it after September 11th to freeze funds linked to designated foreign networks. Obama used it against cyber threats. The first term of the current administration used it to target specific countries and individuals, but no president, not one, ever used IEEPA to impose tariffs. Because tariffs are not asset freezes, tariffs are taxes, and the Constitution is explicit about who has the power to tax. Article 1, Section 8, Congress shall have the power to lay and collect taxes, duties, imposts, and excises. Not the President, Congress. That distinction between freezing someone's bank account and taxing every container entering a port is not subtle. It is the difference between a scalpel and a sledgehammer, and the administration used the sledgehammer. When the current administration declared a national economic emergency based on the trade deficit and used IEEPA to impose sweeping tariffs on nearly every country in the world, the legal community immediately questioned whether it was constitutional. Within weeks, lawsuits were filed. Importers, trade associations, and eventually a coalition of businesses and states argued that IEEPA does not grant tariff authority. The case moved fast, through the Court of International Trade to the Supreme Court on an expedited schedule. In January 2026, the administration stipulated that it would refund all IEEPA tariffs if the court ruled against it. That stipulation tells you something important. The administration's own lawyers were not confident they would win. And on February 20th, they did not. The rates varied, 10% as a baseline. Then higher rates for specific countries, 20% on the European Union, 46% on Vietnam, 50% on Brazil, and tariffs on China that eventually exceeded 145%. The combined effect was staggering. According to the Yale Budget Lab, the effective U.S. tariff rate rose to 16%, the highest since 1936. Before the current administration took office, it was 2.3%, from 2.3 to 16 in 13 months. And the Supreme Court said none of this was legal. The opinion was direct. EPA does not authorize the president to impose tariffs. Taxation is the exclusive province of Congress under Article 1 of the Constitution. Congress did not delegate tariff authority to the president through IEEPA. Therefore, every tariff imposed under IEEPA, the baseline 10%, the reciprocal rates, the country-specific duties on China, Canada, Mexico, India, Brazil, the EU, and dozens of others, is invalid. Now, here's what makes this ruling seismic. Businesses have been paying these tariffs for over a year, every container that entered a U.S. port. Every shipment of electronics, clothing, auto parts, steel, chemicals, food products, furniture, machinery, every one of them was taxed at rates that the Supreme Court has now declared illegal. The total amount collected is estimated at over $175 billion. That money is now owed back to every importer who paid it. The administration acknowledged during oral arguments that refunds would be required. The mechanics are still being worked out. Some importers will need to file petitions. Some may need to go through the Court of International Trade. But the legal obligation is clear. $175 billion in refunds. To put that in perspective, that is more than the annual budget of the Department of Education, the Department of Energy, and the Department of Homeland Security combined. That money was collected, it was spent, and now it must be returned. Where does it come from? That question has no comfortable answer. Now let me explain what happened within hours of the ruling, because the speed of the response tells you everything about the administration's strategy. Section 122 of the Trade Act of 1974 allows the president to impose tariffs of up to 15% for up to 150 days, if there is a large and serious balance of payments deficit. It requires no investigation, no agency review, no congressional approval, just a presidential determination that a payments deficit exists. The president signed the order Friday evening, 10% globally, Saturday morning, 15%, the maximum the law allows, effective February 24th, this Tuesday. Now, critically, this statute has never been tested in court. No president has ever invoked it. And the administration's own lawyers, during the IEEPA case, told the Supreme Court that Section 122 was not applicable to the current situation. They said, in their own filing, that balance of payments deficits are conceptually distinct from trade deficits. That argument is now public record, and it will almost certainly be cited in the legal challenge to the Section 122 tariffs that is coming. Because someone will challenge them. The only question is when. So the United States now finds itself in a position that no modern economy has ever occupied. Its primary trade policy was declared unconstitutional. Its replacement policy uses a law that has never been used, may not survive legal challenge, and expires automatically in 5 months. And the world is watching. Let me show you how the world reacted, because the response tells you how much damage this uncertainty is doing. Within minutes of the ruling, futures markets moved. The S&P 500 surged because lower tariffs mean lower costs for American businesses that import materials and components. The dollar weakened because tariff uncertainty undermines confidence in U.S. economic management. Gold held steady above $5,000. Because the ruling did not resolve the underlying instability, it added a new layer of it, and bond markets, the real barometer of institutional confidence, began pricing in a higher probability of rate cuts. Because if tariffs fall and consumer prices ease, the Federal Reserve has more room to lower rates. But here's the paradox. The tariffs did not fall. They were replaced, within hours, with new tariffs under a different law. So the market got a ruling that said the old tariffs are illegal, and simultaneously got new tariffs that are almost as high. The net effect on actual import costs was minimal, but the effect on confidence was enormous, because the question is no longer, how high are the tariffs? The question is, does anyone know what the rules are? When a government imposes tariffs under one law, those tariffs get struck down. The government immediately imposes new tariffs under a different law. What does a business plan around? What does an importer commit to? What does a factory owner in Vietnam or Germany or Mexico build their supply chain on? The answer is nothing stable. And instability has a cost. It is called a risk premium. Every business that imports into the United States is now adding a risk margin to their calculations. That margin accounts for the possibility that the rules change again next month, next quarter, or in 150 days when Section 122 expires. And that risk margin gets passed on to distributors, to retailers, to you. It does not show up as a tariff on a customs form. It shows up as a price increase on a shelf. And it persists long after the tariffs themselves are gone, because once a business learns that the trade environment is unpredictable, it prices in unpredictability permanently. This is the hidden cost of policy chaos, not the tariff rate, the uncertainty. Governments around the world responded within hours. The European Union expressed cautious relief, but noted that Section 232 tariffs on steel and aluminum remain in effect, and that any new Section 301 investigations could restore duties to previous levels. China, which faces the most complex tariff situation, is reportedly preparing to renegotiate, especially with the president, scheduled to visit Beijing on March 31st. The ruling gives Beijing leverage it did not have a week ago. The UK said its bilateral deal on steel and pharmaceuticals remains intact. But the British Chamber of Commerce warned that the new 15% global rate will still hurt trade and weaken growth. And countries that had negotiated deals under IEEPA, Indonesia at 19%, Vietnam at a reduced rate, dozens of others, are now in legal limbo. Their agreements were signed under a law that no longer exists. Whether those commitments survive is an open question. And in diplomacy, open questions are dangerous because they invite renegotiation, delay, and defection. Here is what this means in practice for businesses, consumers, and the global economy. First, prices. The Yale Budget Lab estimates that the current tariff regime, with Section 122 at 15%, produces an average consumer price increase of about 1%. That translates to approximately $1,300 per household per year. Before the ruling, when IEEPA tariffs were in effect, the figure was higher, roughly $1,700 to $2,000 per household. So the Supreme Court decision provides some relief, but not as much as you might think. Because the administration has made clear it intends to use other authorities, Section 232 for goods deemed relevant to national security, Section 301 for countries engaged in what it calls unfair trade practices, to replicate the IEEPA tariffs before Section 122 expires. The trade representative has already opened investigations into Brazil and China under Section 301. Additional investigations are expected for rice imports, agricultural goods, and what the administration calls countries that produce more than they consume. The goal is clear: rebuild the tariff wall using different legal bricks before the current ones expire. Second, the trade deals. Over the past year, the administration signed dozens of bilateral trade agreements with countries around the world. Indonesia agreed to 19%. Vietnam negotiated a reduced rate. The UK made a deal on steel and aluminum. Japan signed a framework. The question now is, do those deals still apply? The trade representative says yes. Countries that agreed to rates above 15% must honor them. But the legal basis for those agreements was IEEPA, and IEEPA is gone. Several countries are already quietly consulting lawyers about whether they are still bound by deals struck under a law that no longer exists. If those deals unravel, the entire architecture of trade relationships built over the past 13 months collapses, and rebuilding it, with different legal authorities, different timelines, and different political constraints, could take years. Third, the refunds. $175 billion. Importers will receive this money back, but they will not pass it on to consumers. As one economist put it, the retailer is not going to send you a check for the 15% tariff on the shoes you bought 4 months ago. The cost was absorbed at every level of the supply chain. Prices went up. They are not coming back down. The tariffs were temporary. The price increases are permanent. That is how inflation works. It moves in one direction. Fourth, the 150-day countdown. Section 122 tariffs expire in late July. The administration has approximately 5 months to replace them with tariffs imposed under other statutes. If it cannot, if the investigations take too long, if courts block the replacements, if Congress refuses to extend, then effective U.S. tariff rates could drop dramatically. And every country currently negotiating with Washington knows this. The clock gives them leverage. Why make concessions today when the tariffs may disappear in 5 months? Why sign a deal based on a law that has never been tested and may not survive its first challenge? The negotiating dynamics have inverted. Before the ruling, the administration held all the cards. Now time is on the other side. Fifth, the political dimension. 64% of Americans disapproved of how the president handled tariffs, according to a Washington Post and ABC survey conducted days before the ruling. 60% strongly approved of the Supreme Court's decision to invalidate them. With midterm elections in November, congressional Republicans face a choice: vote to extend tariffs that are unpopular with voters and risk their seats, or let them expire and face the wrath of a president who has already revoked the endorsement of a Republican congressman who questioned tariff policy. That is not a policy debate, that is a political trap. And every member of Congress is walking toward it at the speed of 150 days. Here is what to watch. First, whether the Section 122 tariffs survive legal challenge. The statute requires a balance of payments deficit. The administration's own lawyers previously said that trade deficits are not balance of payments deficits. If a court agrees, the replacement tariffs fall too, and the administration is left with only Section 232 and 301, which are narrower and slower. Second, the pace of Section 301 investigations. These typically take months. If the administration tries to rush them, the findings could be challenged as arbitrary. If it follows normal procedure, the tariffs may not be ready before Section 122 expires. Third, the trade deals. Watch whether countries begin renegotiating or walking away from agreements signed under IEEPA. Any defections could trigger a cascading unraveling of the deal architecture. Fourth, congressional behavior. If the House and Senate show no willingness to extend Section 122 before July, the administration faces a cliff, a sudden reduction in duties that would amount to the largest overnight tariff reduction in American history. And fifth, consumer prices. If tariffs drop significantly in July, import costs fall. But it takes 3 to 6 months for lower import costs to reach retail shelves, which means any price relief would arrive just before the November elections. The political calendar and the economic calendar are converging on the same window, and both sides know it. On Friday, the Supreme Court told the president that the Constitution has limits. On Saturday, the president tested a new limit. In 150 days, that limit expires. And what happens between now and then will determine whether American trade policy is built on law or on the assumption that no one will stop you from breaking it. If you want to understand how these decisions affect prices, jobs, and the global economy, make sure you're following this channel, because the clock started on Friday, and it is ticking.